For delivery of order, item number 1.
Looking into the factual matrix, namely the offense is committed to have committed the condition of the accused person, the age of the accused person, the cases cited by the learned counsel for the parties, as well as submissions made on behalf of the parties, and the considered view that this case should be considered on humanitarian ground. The accused person may be given the liberty to allowing him to go on bail, subject to the following conditions. The accused person so and so shall be released on bail in connection with the Canada case number so and so, promising a bail bond of 30,000 rupees, along with a suitable surety of like amount to the satisfaction of the judicial magistrate APR. The accused person shall remain present as an event required by the investigating agency, and the accused person shall not indulge himself in any activities to temper or hamper the investigation process. In view of the aforesaid discussions made during involved, this bail application stands disposed of. Actually, I have to make some correction in this. So we will get this uploaded order maybe by tomorrow. The bail has been granted, but there is some with a long order. So there are some corrections has to be made. So I'll do the corrections accordingly if possible. Today only, tonight if possible, or tomorrow. Tomorrow will be right. Thank you.
Item number 2 for delivery of order.
After perusal of the status quo report as well as statements made by the learned counsel for the accused applicant, this court is of the considered opinion that interim order so passed on 31/7/2025 is required to be made absolute with the same conditions as detailed in the aforesaid interim order. Accordingly, the instant application under section 484 BNSS is allowed. The bail application stands disposed of.
Anybody want to mention the matter?
My lord,
This has been signed. You can...
my lord, I beg to mention one unlisted matter, my lord, will be listed on 21st of this month.
What matter?
Civil revision matter, my lord.
When 21st?
21st of this month.
Yes.
Highly obliged.
Lordship, I beg to mention item number 11.
Item number 11.
11, yes. On behalf of the petitioner. Lordship, the collecting counsel cannot come today for personal difficulties.
Item number
11.
11.
Yes. Matter may be fixed after 4 weeks, and we have taken consent of the other parties as well.
Mr. So-and-so learned counsel appearing on behalf of the petitioner and prays for adjournment of the matter for 4 weeks. It is submitted that he has already taken the consent of the other side. Prayer is allowed listed after 4 weeks.
Deeply allowed.
My lordship, I beg to mention item number 9.
Item number
9.
9.
On behalf of conducting counsel, T. Tapak.
T. Taki.
T. Tapak.
His name is not here. Item number 9, correct?
Yes.
Hmm? T. Tapak. Okay. T. Tapak. Okay.
We have taken.
Mr. So-and-so, you have taken consent of the other side. Mr. So-and-so appeared on behalf of Mr. T. Tapak, who is not available in the court today to argue the matter. He prays for, learned counsel prays for, how much time?
2 weeks.
Prays for 2 weeks' time. Counsel, he has already obtained the consent from the other side. Where is allowed? Use this matter after 2 weeks.
May I lordship? Another matters, item number 23.
23.
Here in respondent set.
Take down. Learned counsel, Mr. So-and-so. Your name?
BCBO.
BCO. Appearing on the behalf of the respondent. You're the sole respondent or what?
Yes.
Appearing for the respondent, prays for 2 weeks' time. As the leading counsel in this matter, T. Tapak is not available in the court today to argue the matter. Prayer is allowed. List this matter after 2 weeks.
Please make sure. Lordship, I beg to mention item number 14, today's bail hearing. Lordship, here the accused person is seeking bail in connection with Aloki's case number 1425 under NDPS Act.
Okay.
So my ground is the charge sheet has already been laid and trial has been commenced. So accordingly, on previous occasion, PCR was called for, but till today it has not been received. So today hearing may not be possible. So Lordship may fix it for after 2 weeks, and in the meantime, PCR may be called for.
You are
I'm for petitioner Kelo.
Mr. So-and-so, learned counsel appears for the petitioner, and he submits that TCR in this matter was called for, and the same was called for. The TCR is yet to be received. A reminder may be sent to the registry
Yes.
calling for the TCR in the instant matter at the earliest.
Yes.
List this matter after 2 weeks.
Deeply obliged.
My Lordship, I beg to mention item number 18 and 19 for the adjournment. I, on behalf of Mr. T. Tofu, Your Lordship,
Why he is not here?
due to health issue, leading counsel is
Yeah. Mr.
Not
So-and-so appears on behalf of Mr. T. Topu, the leading counsel in this in the instant case, and he prays for 2 weeks' time as Mr. Topu is not keeping well. The prayer is allowed. Please the matter after 2 weeks.
Machaula.
So 18 and 19 same. Yes,
Lordship, I beg to mention item number 17.
17. What happened?
Conducting counsel is out of town due to some family emergency.
Who on behalf of?
G. Talo. Lordship, the matter may be fixed for hearing on IA. It's for condonation of delay.
It is come in the orders only. So it will come in the orders only for passing of orders in IA.
No, I've taken the consent from the opposite parties.
MS so-and-so appears on behalf of the petitioner and prays for adjournment of the matter as Mr. G. Talo is not available today in the court to argue the matter due to some personal difficulties. It is also mentioned, it is also submitted that the learned counsel has already taken the consent from the other side. The prayer is allowed. Please this matter after 2 weeks.
Lordship, the matter may be fixed for hearing for
It
condonation.
will come in the order only because we were supposed to argue the IA only. No?
Yes. Obliged, Lordship.
May I, Lordship, I beg to mention item number 16. Lordship, yes, in this matter, I have to file my affidavit in opposition, Lordship. So, Lordship, 2 weeks time may be granted, Lordship. Meantime, I will file my affidavit in
Learned
opposition.
counsel, yeah,
M. Lego.
M.
Lego.
Mr. Learned counsel, Mr. M. Lego, appearing on behalf of the respondents. Respondents has submitted that he is required to file an affidavit in opposition in this instant case. And the instant case, he prays for 2 weeks' time to file the affidavit in opposition. August. The prayer is allowed. Place the matter after 2 weeks for filing the affidavit in opposition.
Item number 3.
Item number?
Wait, please.
Yes.
Wait. My lord knows, before the separation of judiciary from the executive listed, my lord,
Yes.
civil justice was delivered by the village authorities and the executive, my lord. That's, even after the separation of the judiciary, this village authority continues to function, man. So, both should kindly have the Order Code Volume 1 for a moment.
But that I'll have to look into.
AP Code Volume 1.
So your case is that basically this village,
Yes,
Gaonbura should have been the one Gaonbura only because they reside in the same village.
yes, yes.
But
My case is,
but there are 3 Gaonburas who said they and passed their order.
yes, they are from, in fact, different villages.
Different villages.
Yes. In fact, my lord, every village, there already exists a village authority.
Yes.
Supposing Naharlagan is a village, my lord, the deputy commissioner will appoint 3 or 4 Gaonburas as members of village authority of Naharlagan. So he has jurisdiction over Naharlagan. Now here is a case, somebody from Itanagar, Gaonbura from Itanagar, and maybe from some other, 2 of them in fact, they come down here in my village and my lord decide. Totally without them.
What was the provision you wanted to show to me?
If your lordship have kindly have page 53, I think it's the same page, my lord.
Page 53.
Page 53. This is the Assam Frontier Administration of Justice Regulation 1945.
Which this is okay.
The Assam Frontier Administration of Justice Regulation 1945. It is at page 53, madam.
Volume 1 or volume 2?
Volume 1. Page 53, madam.
Page 53 is
Maybe it's a different page in that.
some point this is not 50. It starts from page 50 or check in your book.
In my book, it is 53.
Here it's
Whether I-
50. But which
If your lordship passes to cover, my lord, I will justify.
which provision you wanted?
I want first section 5, regulation 5,
Regulation.
just to show that there already exists a village authority for every village. Yes, my lord, go. It's a regulation 5.
5 is not here only.
So lordship kindly passes on the book, my lord, can I?
Please help me out.
Start from 15 or no, regulation 5 is the less section. Left at top.
Okay.
The deputy commissioner shall appoint such persons that he considers to be members of a village authority for such village or village that is specified and then modify or cancel any such appointment circumstance. Meaning they have a ballot for every village, or maybe if there is a smaller village, there will already exist members of village. They are already appointed, they are already there.
But here now, after this thing also, I mean, this thing is still
Yes.
going on.
I will sort it out. Then your lordship will kindly have section 40.
That's all.
40. 40. That's my lord.
Yes, the village authorities.
Yes, shall try all suits to the limit of value in which both the parties are indigenous to the territory of Arunachal Pradesh and live within their jurisdiction. So earlier, my lord, if there was a dispute, if the dispute was between, supposing, my lord, I am a resident of Naharlagan, only if my dispute is another person staying in Naharlagan, then only, my lord, the village authority put a jurisdiction. That was the position earlier, my lord. Now this has been
No, I mean, 40 says the village authorities shall try all suits without
limit of value.
value, to which both parties are indigenous to the state of Arunachal Pradesh.
And live within their.
Where is that? That is not there in this book. Probably it is, I think that was amended.
That was amended. That was amended. And in fact, I wanted to show the amended portion also.
It is not.
Now it says within the state of Arunachal Pradesh, who are indigenous to the state of Arunachal Pradesh. Yes, my lord is correct. That has been amended now.
So
But,
the village thing is done away.
my lord,
That village part, that living in the particular village has
that
been
part has been done.
done away.
Done. But my lord, the village authority exists for every village. I am a resident of my village. Now, there is already a village authority of my village. There are around 4 or 5 Gaonguras, my lord, who are appointed in respect of my village. So, it is the village authority that has jurisdiction. It is the village authority, my lord, not particular members of village authority that can have jurisdiction. Here is a case, one head Gaonkura from Yakshudi village and another from another village, Talo village. They come down to my village and give this decision. That is in my humble submission impermissible, my lord. Because the decision will have to come from the village authority, my lord. The power is conferred on the village authority. The village authority has jurisdiction.
So village authority is village authority defined anywhere?
Village authority.
Village authority is just section 5 of it.
Section 5. In the state of Arunachal Pradesh, it is admitted position, it is the Gaonguras who are appointed under Section 5. So, my lord will find in a particular village, say, suppose if it's a big village, there will be around 5 Gaonguras and there will be one head Gaongura.
So if there are 5 Gaonguras, the 5 Gaonguras can sit there and
Yes, yes,
and if there is one, he can decide.
yes, yes,
But somebody who has been appointed a village Gaongura in a different village,
yes,
he just cannot walk down
yes,
and
Exactly.
decide a matter in a
Yes.
different village.
exactly.
Correct.
That is this. My lord, I
So
pray
we
for
issue notice.
notice, my lord, in the interim, my lord, we state this, my lord. This is totally the truth.
Heard, Mr.
Deepak.
Deepak, learned counsel appearing for the petitioner. Is rejected by the learned counsel. Pursuant to a marital dispute between the petitioner and the civil respondent, a meeting was proposed. A meeting was supposedly to be held on 19/7/2025 at the residence of the petitioner at my village between the family members and relatives of both the parties. Accordingly, as agreed, the meeting was scheduled to be held at the native village at my 8 Panya district on 19/7/2025. On that date, the family members of the sole respondent came to the house of the petitioner at my village, accompanied by one Nabam Buddha, head Gaongura of Yachili village, Nilam Kapoor, Gaongura of Yachili village, and one Sipal, head Gaongura of
Talo.
Color. It was submitted by the council that the affordances and the above mentioned Gaonguras, 3 Gaonguras, 50 Gaonguras are in fact Gaonguras of different villages and not the Gaongura of my village.
Yes,
Is it
yes, exactly.
my village. It is also submitted by the council that on being asked about their presence, the petitioner was told that they were present only to help in resolving the issue. Accordingly, the meeting was held. Was held, but no solution could be arrived at. And it was decided amongst them that another meeting will be held after a period of 15 days. Though the petitioner was expecting for another meeting, the petitioner received a copy of a decision dated 11/8/2025 are purportedly passed by three judges. You refer them as judges?
Yes, they have referred them to judges in the order.
Three judges, as has been referred in the order. Namely, one Nabam Vida, head Gambura of Actually Village, Nilam Kaku Gambura of Actually Village.
Madam Nilam Kaku, madam, I'm sorry, Nilam Kaku is not even a Gaumura. So there is a mix-up.
Then you have to correct this.
I will correct.
It is there in the petition also.
No, in the petition, it is correct.
Huh?
In the petition, I have corrected that. Sorry, synopsis, but I did not correct.
Petition have corrected.
But petition, I have corrected.
That, then the other line also, earlier I have written this. Nilam Kaku, as Gambura, you have to cut it and you have to write a member of it, which will be. And here also, a member of the Actually. Without him being the Gambura, we have signed it. Right?
Yes, madam, why don't we say page 18?
Please.
18. It starts from 17, it's in 18. Yes, signed it. They refer to themselves as judges. Judges.
Member of Actually Village and one Topo Football, head Gambura of Talo Village. Very was opined that if the petitioner's family fails to terminate the relationship between the petitioner and his Gumpi Ria by 3/2025, the family of the respondent is at liberty to take their own course of action as being recommended. Paragraph. Mr. Pangin, Learned Counsel appearing for the petitioner, submits that the order dated 11/8/2025 was passed without having jurisdiction by the opposite Congress. He submits that as per the provisions of Section 5, Section 5(1) of the Assam Frontier Administration of Justice Company Regulation 1935 provides that the Deputy Commissioner is empowered to appoint such person such person or person of a particular village where it is Gambura coming.
My lord, that I don't have, but this is an admitted position, my lord, under the state of Odisha. The Gaumura is referred. Right.
It says village authority,
Yes.
but it doesn't say
But
Gambura.
it does not say, but the state, my lord, Gaumuras are reported by Section 5. I can produce some orders also, my lord, report also. It's a fact, my lord. I'm making a statement in the park.
He submits whatever it is, right? The Learned Counsel also submits that the Assam Frontier, right? That they appoint persons as village authority, stroke the village Gambura.
Yes, I that case also.
Huh?
It's a pleaded case also. The Gaumuras are referred.
The village Gambura. And he submits that if there is a dispute in a particular village between or amongst any of the villagers who are resident of the village, then the village Gambura of that particular village can only have the power and jurisdiction to decide the issue. Whereas in this particular case, the Gauras from two different villages and one member, two Gauras from two different villages and one member from another village have decided the issue, which is beyond their limits, as per the provisions of Assam Constitution, right, as per the provisions of Assam Constitution. The next paragraph. Having found prima facie material as well as strength in the submission of the 11th Council, this court is of the opinion that this matter may be this matter may be this matter may be looked into in that instance. Issue notice returnable within 4 weeks. The council for the petitioner will take steps by registered AD as well as legal cost within a period of 3 days. Close this matter after 4 weeks. In the interim, having been satisfied with the submissions and the provisions, having been satisfied and looking into the and going to the provisions of so and so act, this court is of the opinion that the justice will be served by giving an interim relief at this time. The order dated, therefore, the order dated
11/5,
11/8,
2025.
2025. So passed as impugned in this
CRP.
impugned in this CRP is hereby stayed until the next day of listing of the matter.
Okay.
Item number 4.
My lord, 4, 5, 6, and 8 are connected, Mr. Madam.
4, 5, 6.
And 8, my lord.
4, 5, 6, and 8.
Yes, my lord.
Yes.
My lord, item 4.
So it has arisen from the same thing.
Same FIR. Yes, same FIR.
FIR.
3 accused. Item 4,
How
5,
many accused?
3 accused.
3.
Yes.
And how come 4 cases are there?
One is criminal petition, and one is criminal
Okay.
for placing the.
So what has happened in the criminal proceeding?
Yes, sir. My lord.
What has happened? There is a statement of the proceeding.
This case has been charged sheeted against the accused.
This case has been charged sheeted.
Yes, charged sheeted, and it is in pending trial for committal process, not yet committed to the session 4. As per this 117 subsection 2 is in session trial. So charge sheet has been filed before that CGM.
And you have come before this court by filing this criminal petition for crossing.
Yes, crossing on settlement as well as I'm still in custody.
You are in custody for how many days?
I was arrested almost 31 days
31 days. Only.
only. 31 days.
Yeah. Yes. So what is the ground of bail?
My ground of bail now charge sheet has been filed. So 107.
Let us go to the FIR first. What was the FIR?
My lord, may kindly come to page 16.
1 second. Case 16.
Yes, 16, 16.
1 second. Case
16. This is the FIR laws against the unknown person. Married or the FIR.
yes.
We, the family member of Mr. Lomio Dugi, is the victim number one, the main victim, are compelled to bring your kind immediate attention to give grave injuries sustained by him in brutal attack and occur on 2 a.m. on 14/7/2015 in Nigam Colony, Nahalagan. The hospital report confirmed that Mr. Sanjay has suffered head injury and a broken nose and is currently fighting for his life. Given the severity of the assault and critical condition of Mr. Such and such, we urge your department to treat this case with utmost priority and urgency. We request a thorough investigation, identification, and for the perpetrators and strong action under relevant section of law. We have obtained crucial evidence that in the culprit has last seen on a spotter bearing such and such. We kindly request that your department utilize the information to track down and apprehend the perpetrators. But this was therefore they have lodged against unknown person. So in course of investigation, this was lodged on 14 July 2025, and on 17 this
was filed on 14
July.
14 July.
Yes.
Then
Then on 17, these 3 accused were arrested. Out of 3 accused, 2 accused is pursuing their BA and another one is pursuing BCom at Northern Hill University, Shillong. There is small young guy. But here, what
so
happened?
all of them are measured.
Yes, major, but student at Shillong. 2 of them are college students. So
So they
after,
were arrested on 17.
yes, 17 July 2025. So after arrest, it was learned that this accused and victim family were relatives. So, though the accused were still in custody, their relative has settled this matter outside the court. So, for that, we have filed this quashing petition, sir. In regards to bail, my lord, my ground is that,
Accused and victims are related.
yes, relatives. They are
But in
having,
view of that, they want to settle the matter.
this already they have settled, though the accused is under custody. I have filed a
They
settlement.
settle means what? By signing an
Settle means-
agreement.
Yes, with an agreement. So, my lord, in regards to ground of bail, my first ground is that the investigation.
So settlement comes, that means like these people are involved. So there is no question of that they are not being involved. They are involved in the crime.
Yes, yes, they are in.
Though they were not named in the FIR,
Yes,
but during the investigation, it came out that and with the settlement agreement, it has proved that they have been they are involved in the crime.
yes, they are
And
involved.
what are the sections that those have been put in?
You know,
in them?
section is
Charge sheet?
170.
It was filed, okay.
Paper was filed on 14 July 2025.
And sections?
Section after investigation is 117 subsection 2 of BNS. Along,
Subsection 2.
yes, no, subsection 3.
Yes, yes.
Yes, which and this 115 subsection 2.
No, this is after charge sheet.
Yes, after charge.
What is the charge sheet?
Charge sheet is at page 20 onwards.
Page 21.
20 onwards.
Okay. Where are the charges?
It's that is in page 22. But 2-3. Second last paragraph. Under facts and subsection. A criminal case under section 117 subsection 3.
The FIR was registered by Navalum Police Station, case number 11 so under section 117(350) of DNS.
Yes. 117 and 115 subsection 2. Public section 3. Subsection
Now,
5.
where is that? I could not find. Where is that?
Page,
Page
page 23.
23.
Yes, concluding part of charge sheet.
In favor of the prima facie,
Yes,
let
and
us see which are the offenses. 117, there are new mistake, no, I don't
This
remember.
correspondent, it's voluntarily causing grievous hurt, my lord.
17 is voluntary, no,
Yes. Subsection 3, corresponding to 325 of IPC, my lord.
yes. Subsection 3 is, what,
My lord, section 3 is no any panel here. It's only regarding group common intention. No any, okay. No any separate panel panel provision.
then 1153, what is 1153?
Causing hurt.
Voluntary causing harm.
My lord, here 115 is payable and component.
115 is available and confirmed.
Yes.
Yes.
And in regards to 117, subsection 3, this section is not at all applicable as per charge. Though they put the several section, but this 117 subsection 2 is not at all applicable. Here,
So 1173 is not applicable.
Yes,
That's what
no.
I say. Hey,
you know, and it's made with this section. Whoever commit an offense under subsection 1 and in course of such commission of any act to a person who is supposed that person to be in a permanent disabilities or in a persistent vegetative state. So these are the indicators, permanent disabilities or in persistent.
so in your
vegetative
case, there is no permanent disability. That's what
No,
you're saying.
not only his nose has been cracked, nozzle
But
bone.
he has got some head injury also.
No, as per this report.
Medical report.
Yes, medical report. I have annexed the medical report.
Medical report where?
Medical report is at page 32 and 33. 33 is the main heredity report.
Multiple bruises around the both the eyes.
Yeah.
Root of nose, lower lip, lacerated own forehead, lacerated own the first palate, hand palate. Fracture of
Fracture, this has been omitted. This is nasal bone fracture. It has been written in column 6, last portion.
column 6.
Yes, option. NCT brain, facial bone, provisional report suggestive of a nasal bone fracture.
But it has been reported as grievous injury.
Yes, it has been. So, Manan, for this, subsection 2 will applicable. That 107 subsection 2.
But your case is that they are not in permanent disability or in persistent
Yeah.
vegetative state.
Yes. If subsection 2 is my lord, applicable, then this is also available and compatible offense.
Which is available? 2.
Yes, 2.
1172.
Yes, 2. And you know this.
1173 is not applicable as
Yeah,
far as your subdivision is concerned.
Yes, but it's not at all applicable.
Okay, now
And another aspect,
and they are
the
fine in jail for how many days?
31 day.
51 days.
Yes.
I mean, they have been sent to judicial custody when? They were arrested when and sent to judicial custody when?
They were produced before
Arrested on
17, and yes, ma'am. On the same day he has been sent to judicial custody.
Same day judicial custody.
Yes.
Where is that order? Is there in order?
No, I have not annexed that order. But on the same day,
17/7.
yes. And after this 1 week, they have filed charge sheet.
17/7, they have been arrested as well as sent to judicial custody.
Yes, ma'am.
Custody on the same day. And charge sheet was filed on
Charge sheet was filed on 21 July 25. Exactly after 7 days.
and mutual this thing, arrest common
Mutual was
agreement.
settled on 14 August 2025.
Mutual agreement on
14 August
14 August
2025. Yes.
Okay. And what is the status of that criminal petition?
No, it is in motion state, this bail also.
Today only? Oh,
Yes.
motion say, oh, I'm
Motion.
sorry. I'm sorry.
All are in motion state.
Okay.
My lord, on bail, my lord.
On bail.
First on bail, then I will come on criminal petition. So far as bail is concerned, this is for the motion, my lord, for the first day. And we
So
don't,
you want the case diaries to be
not case, your lordship, now the matter has already been charge sheeted, my lord. It was, they were arrested on 17, on 21st itself, the
charge sheet on
charge sheet has been filed, my lord.
charge sheet is filed.
On 14, FIR was lodged, my lord, and on 14, they were arrested.
FIR was lost, 17 arrested, and 21st charge sheet was filed.
Yes, madam.
Yes.
And so far as the your lordship, the material whichever they have produced, they have admitted, and your lordship has rightly pointed out, since they are before this court by way of criminal petition also, your lordship. So they have admitted that they have committed the offense, and they have admitted the guilt in the 160 180 statement also. And so far as for the purpose of the bail, your lordship, that settlement cannot be taken into consideration, because the principle for considering the bail is absolutely different, my lord. That the acquisition, the prima facie offense has been committed by the accused or not. And one interesting part is, my lord, possibility of hampering and tampering with the evidence, inducing the witnesses.
But applicable fact is that they are relatives now, they have come to a settlement. What purpose will be served?
Yes, that is there, your lordship. But your lordship, one of the aspect for the bail is whether there is likelihood of your lordship inducing the witness or not. Now they are already been influenced, your lordship, and they are, since they are family relative. I'm not, so far as bail is concerned, I'm not on that, my lord. So the material, everything.
So bail you are not opposing?
I'm not opposing, my lord. Bail I'm not opposing, your lordship, because custodial interrogation is not required. There is no any requirement of custody. Their custody. Yes, nothing, your lordship. Yes, absolutely, your lordship. And
they are in jail for last 31 days.
yes, your lordship.
So
And
bail you don't have any objection.
and it is not directly against your lordship. So far as if they are saying that they are relative, then your lordship, it can be presumed that it is between a private dispute. Is between the parties. Yes. So far as bail is concerned, your lordship, I'm not objecting of the granting, releasing them on bail, my lord.
Okay, then I'll do one thing. This bail I allow.
Yes.
I pass the order before.
Yes, your lord.
Temporarily. Not now, because there are a lot of many matters are there.
Yes.
We have to finish the list if possible. Then what about this this
Criminal petition, I have objection, my lord.
now what it means?
Your lordship, the guiding law, your lordship, the Gyan Singh, Narendra Singh, my lord. No doubt the settlement can be done, but your lordship, the court has to be look into the rule of law, which in what manner it has to be done, who should be the party in settling the matter. Since your lordship, none of them are minor. And settlement, your lordship, is entered by the family member, my lord.
But family members, then
For the victim, your lordship, is defined. See, BNS is defined for the victim. The relative, legal heir, the other kith and kinner, they come under the definition of victim. But for accused, your lordship.
so we can do one thing. We'll issue notice on dates.
Yeah.
We'll issue notice on dates, and bail I'll allow. Bail
Yes.
I'll allow and issue notice on this. We'll hear you later.
Yes, your lordship.
This thing, as far as crossing is concerned. Correct? That will do. In bail, heard Mr.
K. Tapi.
P. Kapoor, learned counsel for the accused applicant. Also heard Mr. P.A.K. learned APT for the state. I'll pass the order in the chamber only, just note down their names, okay, in all these bill applications. And in this other petition, CLP,
Madam, on criminal petition, Your Lordship, the preliminary inquiry will be on maintainability, Madam. Preliminary objection, Your Lordship.
maintenance.
Yes, Your Lordship, because the affidavit, everything has been shown by the relative. And Your Lordship,
Not amongst the parties.
yes, not among, it should be among the parties, Your Lordship, and accused, Your Lordship, even if they are relatives, if they are prosecuted, the prosecution will be against the accused, not with the against the family member, or the family member cannot take that burden or the guilt, Your Lordship. So that has to be taken, that has to be looked into. Your Lordship.
I'll hear you later. I'll hear you on that.
Yes, Your Lordship.
Let me issue notice on
Yes,
this
sir.
now. Notice to go to
Your Lordship, it's state only, Your Lordship.
only state.
Yes, Your Lordship.
So I'll pass the order later. Just mark their presence. Then I'll pass the order.
Yes, oblige, Your Lordship.
Item number 7.
My lord, in this case, I may be allowed to argue, my lord. My learned friend Roji is also there, my lord.
Item number 7.
My lord. My lord, this is a case for quashing of the FIR as well as charge sheet which is submitted, my lord. Lordship, may kindly see the FIR at page 16, my lord.
Page 16.
Yes, Lordship.
Yes.
Lordship, may kindly note one thing, my lord, in page 16, my lord. My lord, date from my lord 2/7/2024 to date 2/7/2024, and the my lord time period, time from my lord, may kindly see, and information received at PS on 7/4/2025. So my lord, there is a delay of almost 9 months to filing the state FIR, my lord. Now, my lord, Lordship, may kindly pay page 18, my lord. This is the FIR, my lord.
1 second.
Lordship.
1 second.
Lordship.
You said that occurrence happened on
2/7, my lord, 2000. My lord, the
and
occurrence
information
happened
received on,
on 2024.
yes, then the information received on 7/4/2025.
25, Lordship.
Okay.
And
What
this
is
of
what
the
is the
FIR is page 18, Lordship. May I read, my lord?
yes.
FIR. My lord, to the
Yes.
officer in police Naharlagan, complaint against Sri Chekka Srinu presently residing at Guwahati. With due respect, it is to inform you that one Sri Chekka Srinu, who was a business partner during the year 2021-22, while he was living in my rented house at Nirjuli, and presently he is residing at house number so-and-so of Patasi Lambari near Sai Baba Mandir, Guwahati. On 2/7/2024, early morning, Sri Chekka Srinu came to my house located near Toa Hotel E Sector, Naharlagan, for some work. As we are good friends, I have allowed him to stay in my house. He also knows the function of my mobile phone since the time of our business partner. On 2/7/2024 at about 9:30 hours, he has told me that he has got a mobile call from Guwahati and his presence at Guwahati is now urgently needed, and accordingly he left for Guwahati. After near about 1 hour, I saw that my mobile headset is not available in my room. I have searched my mobile phone here and there but could not find. Then I immediately gone to the Airtel office Naharlagan and got duplicate SIM. On activation of SIM on 3/7/2024 about 1000 hours, I have got a message that someone has withdrawn an amount of rupees 4 lakh only from my account. I immediately go to the Bank of Baroda branch Naharlagan and discuss about the withdrawal of money from my account with the branch manager. He has told me that this amount has been transferred to account number so-and-so of Sri Chekka Srinu, Axis Bank branch Amingaon, Guwahati, and he has also made a schedule that each day an amount of rupees 4 lakh will be automatically transferred to his account. He has cancelled this schedule and I have left the bank. That I have discussed this matter with Sri Chakka Srinu, and after detailed discussion, he has accepted that he has drawn an amount of rupees 4 lakh from my account, which will be returned by him immediately. But after a lapse of 10 months, he has not yet returned the said money. A detailed transaction and his home address located at Guwahati is enclosed here with for your kind perusal, so and so, my lord. So, my lord, this is FIR, and my lord, I have annexed the document on that particular day, my lord. The informant itself is not at that place, my lord. She was, my lord, she was Allahabad and coming to Guwahati via Delhi, my lord. I have annexed the document along with my petition. Next, lordship may kindly see, after the registration FIR, one settlement deed has been executed between the shown as petitioner and my lord with the informant. Lordship may kindly see page 19. This is the deed, my lord, when the petitioner was, my lord, in jail, my lord. He was custody. He was taken custody due to this FIR. He was arrested on 14, my lord, 14/7/2025, and at that time a agreement was entered into between my lord Sri Chekka, shown as first party, and second party, my lord, Mrs. Sonu Navam. This is the informant, my lord. Even this FIR agreement, lordship may kindly see, my lord, I am allowed to read, my lord. Whereas the second party have mentioned has lodged an FIR against the first party for committing theft and cheating by transferring the money of the second party to his account without consent or without consent of the complainant. And whereas one receipt of the FIR, the OCPS Naharlagan has registered a case by registering the Naharlagan PS case number 47 of 2025 under section 305A BNS. And whereas on registration of the FIR, the accused has been arrested. However, by the request, the family members of the accused, the second party voluntarily ready to compromise the case by way of settlement under the following terms and conditions. Condition number 1, my lord, that on behalf of the first party, the family member of the accused shall pay a sum of rupees 4 lakh only with a week by transferring the lost amount in the account number so and so maintained by the complainant second party. Last time on the page, my lord, that after payment the amount mentioned above, the second party shall be ready to drop the prosecution against the first party before the competent court, and this agreement shall be treated as a piece of evidence to withdraw the prosecution against the accused. Also, request shall be made to IO concerned for filing final report in the case. Third, my lord, that this settlement shall be limited to the amount treated aforesaid and shall not be. Yes, ma'am.
That's fine. Then
Four is important, my lord. That the sole purpose of this agreement shall be maintain goodwill and brotherly relation with the second party in the future, man. So as per this agreement, the case has to be dropped, my lord. They have made the compromise with not the petitioner, with the family member of the petitioner, and accordingly, this family member paid 4 lakh rupees, my lord. My lord, I have the family member of the accused, my lord.
now, who has signed this?
It is signed between the, my lord, lordship may kindly the I have annexed the original one also, my lord. Type copy. Lordship will find it is the informant, my Sonu Nabam, and left side Chakka Kameswari. This is the wife of the petitioner. At that time, my lord, he was in jail. I have annexed the money receipt also, my lord. Lordship will find page 23, my lord.
Receive 4 lakhs.
Yes, my lord. That money receipt is there, my lord. Annex 3, page 23, my lord. In the charge sheet also it reflected, my lord. Lordship may kindly see thereafter, my lord, investigation authority submitted the charge sheet, my lord. Lordship may kindly see charge sheet is page 26, my lord. And in left side column,
305 VNS.
yes, my lord. That is under section 305A. Charge sheet has been filed under section 305A of BNS, my lord. This,
And
my lord,
the-
said about, my lord, theft in dwelling house or means of transportation or place of worship. A is, my lord, whoever commits theft in any building, tent or vessel used as a human dwelling or used for the custody of property. My lord, the
Okay,
charge
now
sheet was
that
filed, my
charge
lord.
sheet was filed.
Yes, my lord. And my lord, my case is that, my lord, there is no such incident happened on that particular day, my lord. And I have annexed the lordship may kindly turn page.
So you haven't taken out the money.
My lord, yes, some money, my lord, they have a business. I have stated, my lord, they have earlier business transaction, and he has to
So
receive
that's why
some money.
So that is
And
why
money
without
also.
telling him, without asking him, you have taken out the money.
No,
And
my
now
lord.
then you return the money.
My lord, may kindly see the FIR of 2/7/2024, and after missing of the mobile, my lord, she has not filed any complaint, my lord. And that
But you
particular
have
day,
admitted it. You have learned counsel. Your
yes, my lord.
client has admitted it, and admitted that money has been taken out without the
My lord,
permission, and
because I
money
have to
has
receive,
been returned. So so there is no doubt that that offense has been committed by you.
my lord, I have stated clearly, my lord, I have some business transaction. I have to receive some money, my lord. And accordingly, my lord,
So
I have,
so that is why without telling him taking the mobile phone, you'll take out the money.
no, my lord,
Only because you had business with them.
my lord, may
Only
kindly
because
see
you
please.
had no, only because you had some business transaction with the petition with the victim. Without
My lord,
telling him or her, he will take
no, my
his
lord,
mobile
this,
phone and take out some money, and
my
later
lord,
on
this
you
is not
admit it
correct, my lord.
and give
This,
it back him, and you say that like there is no offense committed.
my lord, this version of this story of the petitioner, my lord, the informant is not correct, my lord. Lordship may kindly see page 34, my
This
lord.
is your story.
Annexure.
This is your story only, that you have taken out the money, and you have
No,
admitted that you have taken out taken
no,
out
no,
the money, and
no,
you
no,
will
no, no,
return
my
the
lord, I
money
have
in
not taken the,
installments.
I have not taken the money, my lord. My lord, she
So
transferred
what
the
is
money,
the
my lord.
what is
Lordship may
there in
kindly see
the
annexure 9, my lord, page 34, my lord. My lord, on that particular day, I have annexed, my lord, the train ticket, flight ticket, my lord. Lordship may kindly see, my lord. Lordship, in the font, it is Sonu Navam. Again, written Sonu Navam. This is the informant, my lord. My lord, Allahabad to Guwahati, just my lord, between, my lord, just below 2/7/2024, my lord. And timing is, my lord, Lordship may kindly see, 4 hour 50 minutes. And this is the ticket on that particular day, my lord. My lord, she stated in her FIR, my lord, I went there, my lord, at Naharlagan, my lord, Itanagar. And from there, my lord, have taken the mobile phone, my lord. That too also no FIR has been filed, she has. And my lord, on that particular day, my lord, this, my lord, flight ticket lordship itself shows that the content of the FIR itself is a, my lord,
if you
wrong.
have not done anything, why you have signed this compromise deed of
My lord, I have
settlement?
not signed my family, when I was, that also I disputed, my lord.
That
My lord,
this
it's
is
not
your
possible,
document you are submitting.
my lord,
This is your
I have not
document you
signed.
are submitting.
My lord, I have disputed
So
this, my lord, because they compel my family member, my lord.
where is it
My,
pleading upon that in that respect?
yes, my lord, lordship may kindly see. I have clearly stated in my pleading, my lord. Lordship may kindly see. I have stated, my lord. My lord, 1 minute, my lord. So for my lord, I have an excel. Last minute, that as regard to recovery of stolen money, para 9, my lord, the said mobile could not be recovered.
You show me where you have disputed this settlement.
Yes, I clearly disputed, my lord. Last minute, give some time, my lord. Last minute, kindly see, my lord, para 15, my lord. That the petitioner further submit that in this case, the investigating authority also not investigated the case properly, but under influence of the opposite party number 2, illegally recovered the alleged theft amount. During the investigation, the informant compelled the relative of the petitioner to sign the illegal deed of compromise, which is not signed by the petitioner. The investigating authority, considering the said agreement, made the petitioner an accused of the said case, and hence the petitioner is not under any circumstances agree with the said agreement, and as such, from this point also, entire proceeding is liable to be set aside and quashed.
No interim, I'll just issue notice on this.
My lord. So my interim order may be considered after appearance of the opposite party. That may be reflected, Lord.
You have anything to say?
Yes, Your Lordship, Your Lordship is well aware that if he is to annex and challenge the charge sheet, Your Lordship, the entire content of the charge sheet has to be annexed along, Your Lordship. Your Lordship will see at page number 29, Your Lordship. Because while investigating the matter, Your Lordship, the transaction slip, which proves that the transaction was made to the account of the accused, has also been annexed along with the enclosed along with the charge sheet, which has deliberately not been annexed along with the petition, Your Lordship.
So you mean to have, I mean, what your meaning is that an enclosure should have been there with the church.
Yes, because he's
And that is part of the
record.
charge sheet that is not being done, and that has been done intentionally.
Yes, and other part is, Your Lordship, since they are also disputing with regard to the flight ticket, Your Lordship. Your Lordship is also well aware that the documents that is to be produced before the court as a record, Your Lordship, has to be brought into the notice of the court that how did they avail this document. Because when a person's flight numbers are confidential, and unless and until the person does not permit any other person, Your Lordship.
The flight ticket is booked by whom?
This is the flight ticket of the respondent number 2, Your Lordship. And they have
Yes.
annexed it. These flight tickets are confidential in nature, Your Lordship.
What is the page flight ticket?
Page number 34, Your Lordship.
Yes, my lord. I have a next, my lord.
How
My
was
client
this flight ticket?
collected
Because-
from online.
Online, it cannot be, Your Lordship. Even to date, Your Lordship, even if I try with this PNR number to try to get the flight ticket, Your Lordship, I won't be allowed because this is the
Last examine this
flight
aspect, my
ticket,
lord.
flight ticket of the complainant. They want to establish that on 2/7/2024, when the
Sonu Nabam was traveling.
traveling is.
So she was not there in Naharlagun. That's what
Yes,
they
yes.
say.
Yes, my contention
Even
is that.
though, even because this is not even a part of the charge sheet, Your Lordship. And such documents being confidential, Your Lordship, there has to be
That's
amendments made in the petition as to how did the party who has brought this into record has obtained it, Your Lordship. Because there is already an allegation of misusing of the mobile phone of the
My lord,
complainant.
both the-
Also, Your Lordship will, then I'll bring Your Lordship to the charge sheet once again, Your Lordship. At page number 28,
Yes,
In the sixth paragraph, Your Lordship, it starts with on 12/4/2025, Your Lordship.
yes,
The seventh line from that paragraph, Your Lordship will find it starts with during interrogation.
yes,
He has accepted that he has stolen an amount of rupees 4 lakh from the account of Mrs. So-and-so, bearing account number so-and-so, and transferred to his account in 2 installments at rupees 2 lakhs, in each through her mobile. The transaction slip issued from the bank authorities enclosed herewith in support of this case. As regarding recovery of the stolen mobile, the said mobile could not be recovered from Srinu Chekka, meaning thereby the mobile phone through which the offense was committed, Your Lordship, has not been recovered. And then he comes up with this confidential document of a flight of the complainant. So at this stage, Your Lordship, since
I'll issue only notice.
notice of
Lordship, may
I'll
call
pass-
for the record, my lord.
That I'll do. But following the records will be like staying the proceedings.
no, Your Lordship may call for the scan copy of the
Scan
record.
copy of the record.
Yes, my lord.
Heard, Mr.
G
Your name,
Uddin,
please?
Lordship. G Uddin, Lordship. G Uddin, Gyasuddin.
Gyasuddin. Heard, Mr. Gyasuddin, learned counsel, appearing for the petitioner, also heard. So basically, I am passing an order of issuing notice and calling for the scan copy of the PCR. Okay.
Your Lordship.
And it will be returnable within 4 weeks.
Yes, sir.
And in the returnable date, if in the returnable date, that interim prayer will be considered.
Yes, sir.
That observation.
Just write the names and I'll talk about it.
Deeply.
Oh, deeply obliged, your lordship.
Number 10.
None appears in the matter when the matter was called. Listed after 2 weeks. Item number 10.
Item number 12.
Is there not received or received?
But in the case, there is lordship, it's talked about only the, who is not applicant here, lordship. In the item number 12 and 13, here statement, applicant statement was recorded on. So I talked with I personally called the IO lordship. He said,
You are APP?
yeah, PP lordship.
You are PP?
Yes, sir.
Your name, please. Sorry.
Deloy.
Deloy. So what has happened? What you are submitting is that?
I personally talked to the IO lordship. He said that customary inquiry is not necessary.
Custodial interview is not required. Not required now.
Yes,
That is your submission.
yes,
So you are not opposing the bill.
yes, sir.
Item number 12,
13 lordship.
in both the cases.
Yes. Even IO says they are not involved in this activities, lordship. If lordship want to file this,
Then you just give it to me. I'll then accordingly I'll pass an order.
yes, lordship.
And your submission is that?
I plague mark the operative portion, lordship.
Yes. But these orders will be uploaded tomorrow only.
Lordship.
Not today, it won't be possible. I have so many things.
Lordship.
So item number 12 and 13.
13.
13. So first submission is that custodial intervention is not required. And secondly, you said something else?
Lordship, they are not involved involved in these activities, lordship. As offense alleged, lordship.
The charge sheet is filed,
No.
not yet.
Lordship, there are 3 accused.
Hmm.
the one accused against whom there is a prima facie case is not before this honorable court. This,
Okay, other two
the
accused are
other
there.
two are.
In the city lordship, only statement was recorded. Lordship. This applicant lordship.
Their statement was recorded, were recorded.
Yeah.
What about the other one, who is not before the
They are
court?
not applied for.
They have not applied for the bail, but they're inside the jail now.
Yes. Yeah.
For how many days?
Now 2 months and 6 days. Okay.
All three,
Yes, all three.
all three.
Lordship, 2 months and 26 days.
In judicial custody.
Yes. Judicial.
They were arrested when?
Arrested Lordship on 25/5/2025.
25/5,
2025.
2025.
Yes.
And sent to judicial custody on
Same day. Lord.
same day. So I'll pass the order accordingly.
Okay.
These two matters.
Okay.
I allowed him to go on bail.
Highly.
Item number 15.
Affidavit of destiny is not filed.
No, no, man. Last occasion, I was prayed for justice establishment.
So affidavit you have not filed.
No, no, man.
You are appearing for
I'm for a petitioner, man.
Mr. So and so. Learned counsel appears for the petitioner. And he prays one who prays for a week's time
Yes, man.
to file the affidavit with regard to service of notice by way of destiny. Prayer is allowed, listed affidavit.
Yes. All right.
Item number 20.
On respondent number, who respondent number?
Man, all the respondent, man.
All the respondents. So,
Your Lordship, may I pray?
which item?
20, Lordship.
20. Yes.
Your Lordship, in this matter, there is a sole respondent and he have filed affidavit in opposition. Now this matter may list for admission hearing.
You are not filing a reply?
No.
You are
No.
not filing reply?
No.
MS so and so appears on behalf of the petitioner.
Yes.
The petitioner and submits that pleadings are completed in this pleadings are complete in this matter. So the matter may be listed for admission hearing. List this matter for admission hearing after 2 weeks.
Deeply honest.
Item number 21.
Application.
May I please, your Lordship. Lordship, this matter is fixed today for appointment of arbitrators, Lordship. There is an arbitration clause in the agreement.
Correct.
Also, as per that agreement, we're supposed to appoint.
Somebody is appearing in this.
Lordship, on behalf of the PRO, Lordship,
Who is appearing?
DSG was representing. DSG, Lordship.
We are appearing.
Mr. Carter.
What is the submission in this?
Sir, senior counsel is appearing on court number 2, your Lordship.
We'll list it some other day because we have to hear about this appointment. Okay.
Lordship, can it be tomorrow then?
Tomorrow not possible. I have to tomorrow not possible. Maybe in the next week. Mr. Sanchal, what's your name?
T Meto, on behalf of
Appearing
GSCI.
on behalf of
DSGI, Mr. M. Kato.
Praise for listing of this matter in the next week. Prayer is allowed. Mr. So-and-so is present on behalf of the petition. We'll list it in the next week we'll hear it.
Allowed.
Because the matter has to be heard, no? Today it has come for what? Admission hearing.
That-
It's orders.
Order.
Orders. The notice is already issued.
Notice.
You are filing some, this thing, you are not aware.
No instruction. Not aware of that.
You are not filing any affidavit or whatever.
No, sir, I've
This
not
is
given
just for
any
appointment
instruction.
of the arbitrator. We'll list it after a break. Huh?
Item number 22.
Non-appears on behalf of the petitioner on call. Learned PP, Mr. So-and-so, Mr. Loy, Learned PP is present in the court. This is the matter after 2 weeks. So.